Lynn, you can go on. You can also start the recording.
I did.
Okay, great. Hi, folks. It's Del Steady Merced. It's about a minute to 6 o'clock. I just wanted to let you know that I am here. You should be seeing my screen, which has a combination of the PowerPoint as well as El Capitan in the background. If that's not what you're seeing, I can't help you at this point since it's so late in the stage. All right, 6 o'clock, so I'm going to get started.
Well, Capitan is there, Day Steady, but not any PowerPoint.
Do you see my PowerPoint?
No.
No? Okay. Are you seeing it now?
Yes.
Okay, perfect. So now you should be seeing just the PowerPoint, or at least the title page to the title point. It's 6 o'clock. I'm going to get started. Michael Lambert just joined us, Lynn, but now I'm going to just leave it to you to moderate and talk to these people. Edgar, yes, the screen is blank. You should now be seeing the PowerPoint presentation. Okay. Good evening and Happy New Year to everyone. This is Del Steady Merced. Today is Thursday, January 14th, 2016. This webinar is being recorded. In a few minutes, I will be leading this evening's presentation. I will be joined by 3 of your colleagues, I hope 2 of which are on now. The third is not just yet. But that would be Deborah Berger, John Farago, and Michael Lambert. Thank you, Debbie, John, and Michael for joining me tonight. Lynn Beekman is also joining us. He will take the lead in moderating whatever questions and comments come in from you. Before we get started with the program, as always, I must review a few items. First, the training materials were provided directly to each of you via email. The email included an affirmation form. At various times throughout the webinar, I will display various codes that you must write down on the affirmation form. The codes will not be read out loud. I repeat, the codes will not be read out loud. The course code is now being displayed on your screen. The course code is now being displayed on your screen. Please write the course code number on the affirmation form. Submission of, and I'll leave the course code up there for any last minute sign-ons. Submission of the affirmation form with the correct codes is required by the New York CLE Board and by NYSED for continued certification as a hearing officer. Please keep in mind, as NYSED advised you in July of 2015, only IHOs who participate in the entire session of the live webinar program would meet the requirement for participation in the update training and are eligible for CLE units. CLE credit will not be awarded, and the training team cannot attest to your participation unless the codes submitted on the affirmation form are correct and you view the live program for the full 2 hours. Partial participation will not be accepted, and the telephone option is not a substitute for the requirement that you view the live program. Go to webinar tracks the time a participant signed on and off to view the program. I must receive the affirmation form by no later than Friday, January 22nd, 2016. I repeat, I must receive the affirmation form by no later than Friday, January 22nd, 2016. Affirmation forms received after this date will not be considered for CLE credit, and NYSED will be informed that you have not met the training requirement. Second, all participants will be muted throughout the duration of the webinar, with the exception of the panelists. It is our purpose today to answer as many questions and to hear your thoughts on the discussion as time allows. Should a question or comment come to mind during the presentation, we ask that you share either the question or comment using the control panel that popped up when you logged in to GoToWebinar. In that control panel, there's a question dialog box with the wording "Type questions here." It too will accept comments. I will pause to take questions throughout the 2 hours or to hear your thoughts again as time permits. Finally, as I indicated in my email attaching the webinar materials, at the conclusion of the broadcast, a window will pop up that will give you the option to submit feedback through GoToWebinar. Before I begin, I just want to make sure, John, you're on now, correct?
Yes, I am.
All right, thanks, John. And Michael, you are on and you have muted yourself, I can see. And John, you also have the option of muting yourself while you're not responding to any of my questions or to any of my or sharing your thoughts. That might be advisable in the event, just to keep some of the background noise down. The same, for you, Lynn, if you're going to type back and forth with the questions, you might want to mute yourself so I don't hear the typing in the background. All right, let's begin, guys. Course code is on the screen still. Going once, twice, gone. As you might recall, Perry has spent considerable time discussing RE in past trainings. And it is understandable why he might have done so. As one district court has said regarding RE, it is, quote, less than a model of clarity, end quote. Post RE, district courts, the state review officer, and hearing officers have had to wrestle with its significance and how it applies to the facts and circumstances of each case. We've seen district courts as well as the state review officer hold that in unilateral placement cases, i.e. tuition reimbursement claims, a student must physically attend a proposed placement before challenging the recommended school's ability to implement the IEP. In other words, a challenge to this proposed school's ability to implement the IEP could only come after the student was sitting in the school. The fact that the parents had acquired and relied on information obtained post the CSE Committee on Special Education meeting and receipt of the IEP that substantiated their concerns about the ability of the proposed school to implement the recommended IEP was not, in the eyes of some courts and the state review officer, persuasive. In fact, it was deemed, quote, inequitable, end quote, in light of RE, to allow the parents to acquire and rely on this information. RE, however, as we will discuss, does not foreclose all prospective challenges to a student's proposed placement. And this evening, I hope to provide you with a current and concise overview of the case law addressing this specific issue. I must admit, I found reading through the cases cited in my outline extremely challenging because it seems to me that the courts are struggling to apply a rule that is not as black and white as they would like. I will provide some examples of what I mean during the presentation. Quick review. RE, as you might recall, concerned reimbursement claims by several parents whose children are on the autism spectrum. By the time the various cases came up to the Second Circuit, the Second Circuit consolidated the cases. So there were various, I think there were maybe 3, I could be wrong, different cases that the Second Circuit was deciding under one umbrella. In the underlying cases, the school district had used retrospective testimony to rehabilitate what the parents had claimed were otherwise deficient IEPs. In other words, the school district witnesses presented testimony that certain services that were not listed on the IEP, on the student's IEPs, would have nonetheless been provided had the students attended the district's proposed schools. The Second Circuit said, no, you can't do this, school district. You can't use retrospective testimony to rehabilitate an otherwise deficient IEP because the IEP must be evaluated prospectively as of the time of its drafting. The court explained that testimony that materially alters the IEP is not permitted. However, the court carved out an exception to that general rule and said that testimony that explains or justifies the services listed in the IEP would be permissible. This is what we now refer to as a, quote, modified four corners rule. Now, when applying this standard, the standard that they just pronounced, to one of the cases that they were deciding, the court observed that the parents of one of the children was not, in fact, challenging the substance of the IEP, but rather what the parents were arguing is that the written IEP would not have been effectively implemented at the proposed school. Specifically, the parents had argued that children in the proposed school have been and continue to be underserved for occupational therapy. Occupational therapy happens to be a related service which was on their child's recommended IEP. In sparse analysis, the court rejected the parents' argument, saying that its focus must be on the written plan offered to the parents, and concluded that, now I'm quoting from the court, speculation that the school district will not adequately adhere to the IEP is not an appropriate basis for unilateral placement because the provision of a FAPE must be evaluated prospectively. And in this language, in my opinion, when read in context with other portions of the decision, lies the confusion that resulted after RE was decided. What else did the court say? Well, I cite to 3 examples there. Retrospective testimony that the school district would have provided additional services beyond those listed in the IEP may not be considered. You must focus on the written plan offered to the parents. The IEP must be evaluated prospectively as of the time of its drafting. And as such, and perhaps understandably so, some courts, as well as the state review officer, disallowed any evidence regarding the proposed placement's ability or inability to provide services required by the IEP because they considered said evidence to be retrospective and not allowed by RE. Now, adopting such a narrow view by the district courts or by the state review officer would allow, in my opinion, and subsequently in the opinion of other courts, a school district carte blanche to assign the student to a school that could not fulfill the requirements of the student's IEP. And we know that TY, another Second Circuit decision, will not or would not allow this, will not permit this. It would also, adopting this narrow view, require parents to send their child to a facially deficient school prior to the parents challenging the school's ability to implement their child's IEP. This too, it would seem, would have absurd consequences for that child. The fact that the school is terrible, no, send them to the school and then you have a claim against the school district. That would seem to have an absurd consequence. As we know, the parents' rights go beyond simply participating in the development of the student's IEP. Though the school district is not required to designate a specific school on the IEP, this much we know from TY. Parents have a role to play in the placement decision process. And that is to provide input with respect to placement. But IDEA and case law goes further. Parents also have a continuing participatory right to obtain timely and relevant information about the school district's proposed school placement. How else would parents be able to determine whether the assigned school is able to satisfy the requirements of the IEP? To argue otherwise would seem disingenuous, given the weight of the authority to the contrary. And what's that weight? As Judge Engelmayer in the Southern District has said, I'm quoting Judge Engelmayer, the IDEA is solicitous of parents' participatory rights. IDEA is solicitous of parents' participatory rights. The Supreme Court has emphasized this time and again. I provide 4 examples. Rowley, 1982. IDEA's procedural protections, quote, give the parents and guardians a large measure of participation at every stage of the administrative process. Honig, 1988. IDEA, quote, establishes various procedural safeguards that guarantee parents both an opportunity for meaningful input into all decisions affecting their child's education and the right to seek a review of any decisions they think inappropriate. Schaefer, 2005. School districts have a natural advantage in information and expertise, but Congress addressed this when it obliged schools to safeguard the procedural rights of parents and to share information with them. One last example, Winkleman, 2007. IDEA, quotes, sets up general procedural safeguards that protect the informed involvement of parents in the development of an education for their child. Code number 2 is on your screen. Code number 2 is on your screen. Please write code number 2 in the designated line on the affirmation form, please. Code number 2. Now keep it up while I take a sip of water. Code number 2 on the screen. Please write code number 2 in the affirmation form. Going once, twice, gone. In light of the statutory text and purpose found in the IDEA, and consistent with the precedents I just quoted from the Supreme Court, various district courts in this circuit have expressly recognized that parents have procedural rights that extend beyond the CSE meeting and have rejected, and I'm quoting, the myopic conception of a right limited to participating at the CSE meeting. The myopic conception of a right limited to participating at the CSE meeting. That's FB, which is cited in your in footnote 15 of your materials. For example, in CU versus the New York City DOE, footnote 15 in your outline, Judge Coate, I hope I'm not mispronouncing that name, explained, and I'm reading from the decision. The Supreme Court has specifically recognized that parents have a broad right to participate in all decisions affecting a child's education, a right that is reflected in the breadth of the IDEA provisions, because procedural protections in the IDEA are intended to ensure substantive outcomes. It follows that parents have a procedural right to acquire relevant and timely information as to the proposed school. Inasmuch as the procedural protections in the IDEA are broad and intended to ensure that parents have an opportunity to give meaningful input on all substantive issues, the parents had at least a procedural right to inquire whether the proposed school location has the resources set forth in the IEP. Similarly, in VS, again cited to in the materials at footnote 15, Judge Weinstein holds that, quote, I'm reading from the decision, parents have a procedural right to evaluate the school assignment, i.e., the right to acquire relevant and timely information as to the proposed school, end quote. In all, prior to making a decision on the recommended school, courts in this circuit have consistently agreed that, quote, parents must have sufficient information about the proposed placement's ability to implement the IEP to make an informed decision as to the school's adequacy. It's of no surprise, therefore, that the Second Circuit felt compelled to climb out of the hole it created in RE. MO, which followed in 2015, is the court's attempt, my word attempt, as you will hear later on in the presentation, is the court's attempt to clarify the proper reach of its holding in RE. It seems clear, or I should say clearer, now that the court had not intended, the Second Circuit had not intended to take away the parent's right to introduce evidence regarding the proposed school's ability to comply with the student's IEP, which further confirms, and I'm going to say this with an asterisk because as we will discuss later on in the presentation, the Second Circuit seems to be taking some of this away. But it further confirms, at least MO when it was written, it further confirms that the parent's right to participate in the school, that the parents have a right to participate in the school selection process, as well as their participatory right to obtain timely and relevant information about the school district's proposed school placement. So in my mind, MO, and when you read it and read it in context of some of the precedents we talked about, some of the other decisions that the lower courts were deciding, confirm that parents have a right to participate in the school selection process. I'm not saying that they have veto power, but they have a right to participate in the school selection process. As well, MO confirms that parents have a participatory right to obtain timely and relevant information about the school district's proposed school placement to allow them to make an informed decision as to the adequacy of that school. MO clarifies that testimony explaining how the IEP would be implemented in the proposed school is sufficiently prospective, not retrospective, and may be considered by the court, state review officer, hearing officer. The inquiry, as stated by the court, is, quote, whether at the time the parent was actually considering the proposed placement, the school could offer services in line with the IEP. Notably, and I'm going to digress for just a moment here, one must assess the merit of the parent's challenge at, quote, the time of the parent's placement decision, end quote, which I would presume is sometime after the CSE meeting, yet leaves open the question as to precisely when that is. Is it when the parents are in receipt of the bricks and mortar placement and after they've had a reasonable opportunity to investigate whether the proposed school location has the resources set forth in the student's IEP. And if that is the case, how does a last minute notice to the parents by the school district change that equation? Or the parents' inability to get access to the proposed school or to knowledgeable staff because the notification came, for example, over the summer. What if the parents signed the private school contract prior to the CSE meeting or receipt of the bricks and mortar placement notification? Does this alone cast doubt on the parents' challenge, only to be overcome by convincing evidence that despite putting the cart before the horse by signing a contract, perhaps because before they even met with the CSE, or perhaps after meeting with the CSE, but before they got the placement recommendation, they were nonetheless justified because of the proposed school's inability to meet the requirements as set forth in the IEP? And if that's the case, that they can come in and offer this evidence, even though I've done this, even though I've signed the contract, even though I've done it before I even got a placement notification, I should still be allowed to argue before you, hearing officer, that the school is unable to meet the requirements set forth in the IEP. If that's the case, does this raise a question whether that testimony is retrospective and impermissible under RE? Here again, it seems to me that the Second Circuit falls short on answers. And undoubtedly, the facts and circumstances of each case will be determinative, and it will be up to you to make a reasoned judgment as to what is meant by at the time that the parent was actually considering the proposed placement. I want to pause for a minute here, and before I continue to discuss MO, I want to get the panelists' reaction. Lynn, John, Michael, Debbie, as to how might you approach deciding what is meant by this open question of at the time of the parent's placement decision. Everyone's jumping over each other to jump in.
I might only note, Study, that we've got a lot of people that I've been responding to are having difficulty saying their screen is blank for the codes or one thing or another, and obviously there's nothing we can do. We regret that, but there's nothing we can do now that the session's going on, and I'm referring them to that registration number at the bottom of their email, which told them to register. There was a number there for help.
Yeah, you're seeing my screen on your end, right?
Yes.
Okay. Yeah, I'm sorry about that, but there's nothing I can do at this juncture to assist you. But as Lynn says, I provided you with an 800 number on the registration email that went out January 4th. If you have any snafus, they answer very quickly, and they can walk you through it and help you get on. John, I saw that you unclicked your mic, so I'm assuming you have something to share as well as Michael. So let's start with, or even Debbie. So let's start with John.
Well, that probably overestimates my technological skill, but there is one of the federal court decisions that you've cited specifically says that the FNR has in it language that the parent must sign and return it, I think by a date certain. And that court used that triggering event as the date on which the parent had to decide whether or not to accept the placement.
Yes, and I have a case that I'm going to talk about that where those facts I do believe come into play. But again, it's an open question. So yeah, continue, John.
Just and that practice, the practice of providing an FNR and giving the parents the opportunity to visit the site. I mean, very strong claim, because many times, inevitably, the opportunity is not there because the classes are not in session at the time they're built. But the practice of allowing parents actually to visit the site that's proposed for their child was even alluded to in RE, and became the premise in RE on which the court built the notion that the parents had adequate opportunity to see the actual placement and challenge it.
Yeah. So that's something. Thank you for highlighting that. Yes, I think that is a factor. But as we're going to discuss in some of these cases, you start to scratch your heads because, as any one of us, there are 116 hearing officers, 115 in New York. We might all see it differently, and MO at least kind of throws this language out there at the time of the parent's placement decision. And it's not entirely clear to me, what that means, and can be interpreted differently. Let's hear from Debbie or Michael. Let's start with Debbie.
My thought is twofold. The first thing that I think about is some parents make a claim that they have to see the actual classroom setting in order to determine whether the placement is appropriate. And I think that the cases are now pretty clear that that's not a requirement in order to have an appropriate IEP and a placement. So for me, the issue is placement more towards, is the school have the ability and the class recommendation size available for that student. And I'll give you an example of a case that I actually had as a hearing officer where the placement was actually a 12-1-1 IEP placement, and the school that the child was recommended to didn't have that class available. So at the time that the parent was making the placement decision, when they met with appropriate school personnel, and I know you're going to be talking about the latter case on credibility and things like that about what you're told at that meeting, it was clear that that placement was not available. So I think that you should allow testimony as to the parent's decision-making process and how that came about in terms of whether or not to accept the placement.
Yeah, and I'm going to get to that, but Debbie, I want to get your thoughts on, if you were sitting there and the issue came up before you. It says, MO says that, it's at the time of the parent's placement decision. Hearing officer, we have introduced evidence that this parent, signed a contract months ago to keep their child there in a private school. Anything that they say moving forward regarding the placement school's ability to provide the services on the IEP should be excluded because the parent was never going to consider this placement. And two, I like to argue that it's retrospective evidence. How would you look at that?
The first thing is, I think my question is, has the parent, they've put the contract in. I'm assuming you're saying that the contract is in evidence before me. It doesn't have a clause that we normally see in most of the contracts that says if you accept a New York City placement, you get your money back, or a school placement.
Yeah,
So
they've
I'm
gotten smart about that since I was practicing. I've never seen that, but I hear that that is now a common
That's pretty
practice.
much the standard MO
Yeah.
in the contracts that you see now, at least for the New York City private schools. So if I'm assuming it doesn't have that clause, that's the first
Right.
thing. So without that clause in there, I think it goes to really a question of credibility. So as a hearing officer, I would allow the testimony in, but I would then make a decision on credibility dependent on what the parents' testimony is regarding were they really considering the school placement or not.
Okay. And we're going to talk about credibility as well in one of the cases. Michael, do you have any thoughts to share?
What about the second part of your question, Mayor Steady? You didn't give Deborah a chance to respond to the second part.
Oh, sorry. Yes, the retrospective. I'm sorry.
I would say that I don't think it's retrospective testimony because I look at time of parents' placement decision at the time they're actually getting the information about the placement, not at the time of the CSE meeting, because especially in New York City, you don't know what that placement is going to be. And I think that looking at it from the perspective of the child, which I try to do in cases, is does the parent have the right to make a decision in terms of what education the child will receive and whether the IEP and placement will be appropriate? My answer is yes, because you don't want the child to go to a placement that's not going to provide an appropriate education to the child. So I would not really consider it retrospective.
Okay. Michael?
Yeah, I wouldn't consider it retrospective either. I think if a parent takes an action to secure what they believe to be an appropriate placement for their child at a time when the district has not yet offered a bricks and mortar placement for them, I simply don't think that that precluding them from testifying concerning that would be retrospective or even equitable. I think that there's nothing in MO that was intended to eliminate the district's ability to assert a prong three challenge to this. They can allege that the district didn't intend to consider any placement recommendation that they made. And also, I don't think that a late or an untimely notice by the district as to what the specific bricks and mortar placement was going to be should be at least under the equities, held against the parent. The parents have the right to take actions to secure what they believe to be an appropriate educational placement at a time that is timely to secure that seat. And I think that at the time of the parent's placement decision has to be measured in terms of when the DOE was actually making a recommendation for them to make a decision about.
Right. So you would seem to agree that, the fact, as you said, the fact that the school district waited to mail out that notification, and it's the summer and the parents don't have an ability to even access information, et cetera, it should not be held against them. And the parent can at least put that forth in the record for you to consider in making a decision as to whether the parents did what they needed to do based on the circumstances of their individual case.
I think that presents a legitimate question of fact that that should be decided by the hearing officer.
Excellent.
Case study?
Yes, John.
I heard Mike also to be making the extraordinarily important point that it's very easy, and the courts frequently do, mix up what one could call a prong two challenge with an equitable challenge. I think many of these questions arise in talking about the equities, and that's fine, and MO leaves your capacity totally untouched as to deciding the equities. It just says that it's not a per se bar to the propriety of the parental placement or to a determination that FAPE was denied.
Yep, and I thank you for highlighting. Micah, did you want to respond to that in any way, or?
No, I agree with John's assessment. I think that point's legitimate.
Excellent, excellent. All right, so let's move on.
Well, hold it, Dave Spitty. I have a question for it.
Okay.
The question is, does MO now allow the district to cure an IEP by explaining how the IEP would now be implemented at the time of placement, even if the IEP was deficient at the time it was made?
Well, hold that question, Lynn, because we're going to talk about that when I start analyzing some of the cases, and then we can come back to it at that point. So hold that question, okay?
Yep.
Now, as Mo points out, and if you haven't read Mo, I hope you do. Not all challenges to the adequacy of the proposed placement school are the same. The court makes a distinction. The Second Circuit attempts to make a distinction between permissible and impermissible challenges to the substantive adequacy of the proposed placement school. But as we're going to discuss, the distinction, in my mind, is far from clear. And the circumstances under which courts have determined that some challenges are better than others appear, in my eyes, in this reader's eyes, quite subjective. But perhaps this subjectivity satisfies our natural craving for expansive discretion. You're going to have to be the judge when you read these cases on your own. Specifically, Mo makes a distinction between deciding that a placement was inappropriate because, quote, a school with the capacity to implement a given student's IEP will simply fail to adhere to that plan's mandate. We can do it, but the argument is they're not going to do it. And a finding that the placement was inappropriate because, quote, a proposed school lacks the services required by the IEP. This is a school that can, for whatever reason, they can't provide the services. Perhaps it's because it's an ADA non-compliant school, and the child is wheelchair bound, and they just got the placement school recommendation, and there's no way that we're going to make this school compliant in 2 weeks. That might be an extreme example of that. The first challenge, according to MO, and the first challenge.
Excuse me.
Yes.
I actually had that case. This is Debbie.
Yes.
I had that case.
Which case?
New York City. What you just said.
Oh, my example. Okay.
Yes, I had that case where a school district, the IEP was fine. The child was unable to walk upstairs. The building had an entryway with 2 staircases and no elevator, and the assigned class was on the 2nd or 3rd floor. So that case exists.
Okay.
Of course, I found that the placement was not appropriate and awarded tuition reimbursement because I found the placement was.
And that's an example of a school that, for whatever reason, it can't comply. So let's just look at these 2 distinctions that MO is making. The first distinction, you recall, is a school with the capacity to implement the student's IEP will simply fail to adhere. According to MO, this challenge is not permissible and an appropriate basis for unilateral placement because the court sees it as, quote, sufficiently speculative, end quote. From the court's view, it would be merely speculation that the proposed placement school, which has the resources to implement the IEP, will nonetheless fail to adhere to it. The court simply refuses to engage in hypothetical challenges, i.e., what might have happened if the student had enrolled and attended the proposed school, the proposed placement school. We're not going to entertain that claim. Highly speculative, sufficiently speculative, not permissible under MO. The same is not true as to the second. Prospective challenges, and the second, as you recall, is a proposal that the school lacks the services required by the IEP, i.e., they don't have the capacity to do it. Prospective challenges are permitted if they concerned, as I just said, the proposed school's capacity to implement that IEP. Stated differently, a challenge to the proposed placement school will be successful if it can be established that the school is, quote, wholly incapable, end quote, wholly incapable, court's words, of implementing the services listed on the IEP. Let me pause there for a minute and give you code number 3. Code number 3 is now displayed on your screen. Please write code number 3 in the designated line on the affirmation form, and while I keep it there for a couple of more seconds, just going to take a sip of water. Code number 3. 3, 2.
This raises a very important question I've always wondered, which is whether there's an E in holy.
Yeah.
You know, I would pronounce this Wally. But
well, listen, that's not today's topic for the seminar. Perhaps Perry would have given you a very different answer, including whether it was a passive sentence or not, but I'm not going to take that on. All right, code number 3, we're moving on. It's on your screen. It's now gone. All right. I want to take a look at 4 cases to better understand the distinction the court is making in MO. The 4 cases listed on your screen are BK versus the New York City DOE, Eastern District, 2014, decided prior to MO, but after RE. Then we have BP versus the New York City DOE. And BP is the latest decision from the Second Circuit on this issue. It was decided, and don't quote me on this, or at least it was issued around December 30th or thereabouts of 2015. Then I want to go back and look at DC versus the New York City DOE, which is a Southern District, New York case from 2013. Again, prior to MO, but subsequent to RE, it's my recollection. And finally, TF, which is a early fall case from the Southern District decided in 2015. And I specifically put these in order because I want to make some points that will help with our discussion and reaction from the panelists. Let's start with BK. BK is cited to in footnote 24 in your outline. Here we have a father of an 8-year-old child who is diagnosed with an autism spectrum disorder. And the father visits the proposed school with a teacher from the student's private school. My recollection is that the student had been placed in a private school the year prior, funded through the New York City DOE. Don't know whether it was because of a win in an impartial hearing or whether through a settlement agreement. I don't recall. But the father goes, visits the proposed school placement and brings along the teacher. The father determined that the school that was being proposed was inappropriate because, one, the student would not be grouped based on individual needs. Two, the staff was inadequately trained to provide proper behavioral interventions. And here we had a child with a behavior intervention plan, a BIP, and the father's argument is the school staff is not adequately trained to carry out um, what is being required in that BIP. And three, that the school lacked sensory equipment required by the student. In addressing the father's three concerns, the court agreed with both the hearing officer and the state review officer that this prospective challenge was not permissible because it was based on assumptions. With respect to the functional grouping argument, the court determined that the father's objection was, quote, predicated on the assumption that the student would be placed in a particular class, end quote. The school, as the record indicated, had three potential options of 6-to-1 classes, which was the recommendation on the IEP. And according to the court, any one of these three classes could have been a class that the student would be assigned to. And the court pointed out that the father assumed that the school was not able to functionally group this child because at the time of the notice, this is a New York City case. The notice comes out in a document called the Final Notice of Recommendation. The FNR, the Final Notice of Recommendation, did not assign a particular class to the student. And neither was the father advised of a particular class that the student would be assigned of the three potentials on the day that the student visited. And in fact, the facts of the case were that the father sat in one class and assumed that this would have been the class that the student would have been assigned. And as any court who wants to cover itself, I believe, and my recollection is the court then goes on to say, and even if it were the class that the student was going to be assigned to, the student could have been functionally grouped in that class. So the first argument is set aside. Father, you assumed, no go, I don't buy it. Court then approaches the second argument having to do with the adequacy of the staff to be able to implement the behavioral interventions in the BIP and the behavior intervention plan. The court here too rejects the father's argument. Interestingly, the court rejects the father's argument, recognizing that the lead teacher, who was a witness for the school district, offered testimony, quote, in broad strokes and often without precision on the matter. Court said, Father, you know what? I'm not buying it either. And I understand that the teacher kind of talked about it in broad language and really didn't give us any precise information, but I'm not buying your argument. You're assuming that the staff is not properly trained. You lose in this argument. Third argument, the sensory equipment. The court again was unmoved by the father's concern that the school lacked various suspended equipment, which are types of sensory equipment, called for in the IEP. The court noted that the father was unable to show that the school was unwilling or unable to obtain any equipment necessary had the student enrolled at the school. Had your child showed up, they had a requirement to purchase this equipment or to make sure that they had it on premises. Therefore, father, your child never showed up. The fact that it was in there during the visit, it doesn't matter because they could have purchased it later. You're making assumptions. You lose. I present this case as a background to discussing the other three, but any immediate reactions from the panelists on BK? Not hearing any, I'm going to move on to BP. BP, as I said earlier, cited in the materials at footnote 29, is the most recent case from the Second Circuit on this matter. Here, the parent took a tour of the recommended school and was told by the school's social worker that the school did not have the requisite staffing or space to provide the student with pull-out occupational therapy, OT, and speech services required by the IEP. School social worker informed the parents of this during the tour. At the hearing, this is again, and I just want to emphasize this so that we understand the implications of the decision. At the hearing, this is after the visit, after the parents presumably submitted a notice of unilateral placement, which is required under the IDEA and tuition reimbursement cases anytime the child's being removed for the first time from a private school. And after the parent filed their due process complaint. At the hearing, the school district introduces the testimony that had the student attended the school would have made it work. We would have made it work. I.e., we would have provided the services as directed in the IEP. We have a room that we could have put this child in with an occupational therapist. We have a room that we could have put the child with a speech and language pathologist as provided and directed in the IEP. The parents argued that the school district should be stopped from remedying faulty information at the hearing. Hearing officer, don't allow this. This is the first we hear of it. Don't allow this. The Second Circuit, after they went through, obviously, various appeals, refused, saying in part, quote, "We refuse to essentially impose strict liability," end quote, "for reimbursement based on any misinformation provided to the parents prior to the student's enrollment." The court found that the parents bore the risk of relying on information from a single school official. If that language, bore the risk, sounds familiar, it's because the court went back to Carter and Burlington and says, hey, parent, you bear the financial risk that ultimately the school district can demonstrate that, in fact, it provided the child a free, appropriate public education. Borrowing on that language, the Second Circuit found that the parents bore the risk of relying on the information from a single school official. I highlight that because I'm going to come back to that. If you're scratching your head, I was scratching my head as well after reading this. BP raises a number of questions, including from a practical standpoint. What must be included in the hearing record to convincingly find that the parent's testimony is not too speculative when they've based their decision on the information provided by school officials? Is it simply that they've verified whatever information was provided with more than one school official? Here, it was only a social worker, school official nonetheless. There was only one. Do they need to verify the information with more than one school official? What if the parents were not given access to any other school official? It's my understanding that in some schools, the parent's point of contact to getting entry into the school is, I think the title is parent coordinator. I could be wrong on that. In this case, it was a social worker. What if the parents are not provided access to anyone else, just one school official? Must that now need to be asserted on the record by the parents that we attempted to verify this information that we received from this one school official by reaching out to the principal, by reaching out to the assistant principal, by reaching out to the special education coordinator, the school psychologist, whatever title you want to fill in? Would it be sufficient for the parents to demonstrate not only that one school official shared this information, but also that they confirmed their understanding in a follow-up letter that the school district did not respond to before the parents made their placement school decision? Is that now something that needs to be included in the record? Now, why am I asking all these questions? I think that given BP, given MO, and as you're going to see, these cases kind of build on each other, we need to, as hearing officers, to start thinking about these types of questions when prepping for cases in which the parents are alleging a prospective challenge. It's a discussion that I think would need to happen prior to the hearing, perhaps at a pre-hearing conference, if you are conducting a pre-hearing conference, in order to ensure that the parties are prepared to provide you with the information you will need to make an informed decision in the matter. Or perhaps for you to be prepared to ask the questions directly of the parties, because as we've discussed in the past, in New York, you have the added benefit, the authority to complete the record. Now, keep BP in mind when discussing our next case, which is DC.
Before we go on to the next case, though, if I, maybe we ought to do this, if I was keeping a list of the top 10 dumb, impractical, misguided decisions of circuit courts around the country, this BP decision would be right on that list. I just can't believe that they would misinterpret Burlington in terms of the range of risk that a parent incurs with a Burlington Carter type case. But anyway, I just couldn't hold back. I think this is one of the worst decisions I've read out of the Second Circuit.
I'm sorry, Linda, doesn't that case really just stand for the proposition that it's a question of fact as to whether it was reasonable for the parent to rely upon the statement of that one individual? Lots of folks are involved in developing IEPs and offering the IEPs. If it was reasonable for the parent to rely upon that one person, then I think that may very well be a meritorious claim for the parent. But if you have one person in a team of 15 people who are involved in the process making a statement, why should a parent be able to cherry pick that dumb statement and build a successful reimbursement case based upon that.
I believe the facts here show that the district picked a social worker to give the parent a tour. It wasn't the parent cherry picking.
Yeah, well, but it is a procedural question, I think. The case goes to the Second Circuit on appeal from a district court decision favoring the district, and which is entitled to considerable factual deference by the Second Circuit. So the narrow question before the Second Circuit in this tiny little decision is simply whether the estoppel claim should be granted. And estoppel is like a blunderbuss. It's a huge club. To grant estoppel, you need a hell of a lot of convincing reason to do so, because you're barring a party from putting in evidence on factual claims. So all I would say that BP stands for is that the district was not stopped from making its best case.
Yeah, but the circuit court, I mean, a parent doesn't risk misrepresented information from the district in terms of the risk it assumes when it's seeking a private placement.
No, I agree with you that sentence is a really stupid sentence.
I'd like to finish that the IEP the district proposed was inappropriate. That's the risk Burlington says the parent assumes.
Yeah, I agree totally. That sentence is a colossally stupid sentence.
Yeah,
but the decision is a very narrow decision.
I think I would agree with you, John, that it is narrow. It can be read to be very narrowly. I agree with you. It's a short decision. But I think when I read this, I says, is it that they wanted to get home for the holidays? I mean, it did get issued, right before New Year's. It was, in my mind, not a very well worded decision, and it raises a lot of questions that I think ultimately, as I will indicate later, but I will say right now, is I think ultimately you're going to get BP type arguments that go beyond the estoppel. But I do want to, there was one last point before I got to DC that I wanted to point out. And it goes to what Michael just said. The court noted the following, and I want to highlight it. I'm reading from the decision. To the extent there was conflicting testimony from BP and the social worker who served as plaintiff's placement school tour guide as to what information was relayed on the tour, the initial hearing officer was in the best position to assess credibility, which he did in the favor of the social worker. The record provides no reason to disturb that finding. I highlight this to impress upon you the importance the Second Circuit places on making credibility findings when it matters. The Second Circuit is not coming back and saying, listen, we're going to defer to the state review officer on this one. The Second Circuit is coming back and saying, listen, this hearing officer, and I suspect the hearing officer might be out in cyberspace hearing this, and if there's some insight that I'm not aware of because it's not included in the four corners of the decision, send us a comment, send us your perspective. We would love to hear it, and Lynn can read it to the rest of us. But the Second Circuit is making clear to you as a hearing officer that credibility matters. When it matters, make those credibility findings, especially on something like this where, I don't know what word you use, Michael, in terms of referring to the social worker's testimony or whatever the social worker said at to the parents. But it was clear that the Second Circuit is saying when you have a he said, she said, hearing officer, make that credibility finding. It's going to be crucial. Let's talk about DC.
If I could just say again that speaks to the estoppel issue, that's what this court is hearing, and people need to be conscious of the fact that all they're saying is you get to make your arguments. You're not stopped from making arguments just like the one you just laid out, that the hearing officer heard, the SRO heard, and the district court heard, all ruling in the same way. before the case gets to the Second Circuit.
Yeah. And that may very well be true, yet I don't think the Second Circuit articulates it as well as I think you would have hoped, or you at least are articulating it to the rest of us. I think it was a sloppy decision, which I think will have some ramifications. I'm not saying that you're wrong, John. I'm saying that it's going to open the floodgates to some new arguments, especially when you look at it, comparing it to MO and some of the subsequent decisions that came out after MO with respect to applying MO and deciding what's speculation and how do you decide what's speculative or not. DC. Southern District, New York, 2013, prior to MO. It's cited in footnote 8, but I think it's an important decision. It involves a student with a severe seafood allergy. So severe that it causes anaphylaxis if he ingests, comes into contact, or smells seafood. No one disputes that the student requires a seafood-free environment, and in fact, the IEP is drawn up, and it includes the necessary information regarding the student's medical needs. On June 14th, and I provide the dates because they matter in the context of the facts of this case. On June 14th, the school district mails to the parents a notice of placement and further advises that they must respond by June 28th or the placement goes into effect. This is what John, I think, was referring to earlier. June 14th, they probably got it 3 days later, so they would have had approximately 11 days to respond to the final notice of recommendation. Again, this being a New York City DOE case, and the placement school notification is called a final notice of recommendation in New York City. The next day after receiving this notice, the parents call the school to arrange a tour and are told that the earliest tour date is July 13th, almost 2 weeks after the deadline set in the FNR, the final notice of recommendation. During this discussion, the parents are also told that all of the children in the school are served lunch together. The parents write to the school district saying that they cannot make a decision on the placement school before the deadline listed on the notice because their tour was set for after the deadline. Parents get no response from the school district. Before the actual tour, the parents unilaterally place the student in the summer session of a private school and provide written notice. And I'm a little foggy on the facts, but my recollection is that this was a child who had summer services on the IEP, but it really doesn't matter for purposes of our discussion. So they placed the child in a summer session of the private school and provide written notice of the placement to the school district. They provide that removal notification that's required under the IDEA anytime that you're going to seek reimbursement from the school district. The notice of unilateral placement advises the school district that the parents have reservation regarding whether the recommended school can accommodate the student's allergy, given what they were told when they called to set up the tour date. And that was, you might recall, that all children eat lunch together. On the day of the visit, as it would happen in any case like this one, the parent comes to the cafeteria, and posted near the cafeteria is a lunch menu. Seafood is on the lunch menu. The parents are also told that the school is not seafood free and that students are permitted to bring lunch from home, which could include seafood. By this, I assume it's a tuna sandwich, unless, these kids are bringing a more sophisticated sandwich to school or meal to school. The parents are also told that seafood is prepared in the on-campus work site cafeteria, which is housed on the third floor, as well as seafood is also prepared in the teacher's lounge. Parents also take the opportunity while they're in the tour to speak to the school nurse, who confirms that the environment is not seafood free and explains that the school could not control for the allergy. The parents are told it's not a seafood school and we can't control for this allergy by the school nurse. The nurse explains that the student would be isolated for lunch during the days when fish would be served. He would be kept back in the classroom with a school aide, and let's hope that someone is not walking by with a tuna sandwich. The parents reject the placement school in writing and explain why, but they also advise the school district that they would be willing to consider an alternative placement school. None is offered. The CSE, the Committee on Special Education, do not offer an alternative placement. Nor does the school district correct any of the misimpressions that may have been created during the tour. At the hearing, again, this is after the notice of, after the parent have filed the due process complaint. At the hearing, the school district introduces the testimony of the assistant principal of the school as well as the nurse. And they testify that, contrary to what the parents were told, seafood was not served in the cafeteria, and that lunches were brought from home by students were checked by the staff. First, the parents hear of this at the hearing. The assistant principal further explains that had the student attended, tuna would have been removed from the menu in the on-campus worksite. Neither the assistant principal nor the nurse, as I said, shared this information with the parents prior to their testimony. This is the first they hear of it. Hearing officer finds against the parents and credit the assistant principal and nurse's testimony over the parents. The state review officer agrees with the hearing officer and upholds the hearing officer. Appeal taken to the district court. The district court reverses the state review officer, stating in part, and now I'm quoting from the decision, the testimony from the assistant principal and nurse was too little, too late. It was too little because the school was not a seafood-free environment at the time of the parents' visit. And it was too late because the proposed methods to control the environment were only explained at the IHO hearing, almost a year after the parents had to make the placement choice for their son. End quote. The court goes on to explain that the assistant principal and nurse's testimony should have been, quote, limited to information that was reasonably known to the parties at the time of the placement decision. Very different case. Understanding that this was decided before MO, but I think it makes some points. And I'd like you to permit me a few observations as I have on the two other cases. First, though DC is a Southern District decision in 2013, the Second Circuit cites to its holding with approval in MO. The Second Circuit in MO cites to DC with approval. Specifically, the Second Circuit says, and I'm quoting from the decision in MO, It is not speculative to conclude that an IEP recommending a seafood-free environment for a child with a life-threatening seafood allergy could not be implemented at a proposed school that was not seafood-free. But is DC a true example of a case in which the proposed placement school does not have the capacity to deliver the environment called for the IEP? One can argue that DC is an example of a placement school's disinclination to adhere to the student's IEP. And if true, then one can argue that not only challenges against placement schools that are, quote, wholly incapable, end quote, of implementing the services listed in the IEP are permissible, but so should challenges in which the parents can point to definitive evidence as it pertains to their child, that despite the school's ability to provide the services, whether when the parents make their placement decision or thereafter, it will not. That's the first observation I want to make. The second observation I like to make is the importance of establishing a comprehensive record of what transpired at the time the parents made their placement decision. Unlike BK and BP, in DC, the court, in painstaking detail, outlined the efforts of the parents to secure information about the placement school's ability to provide the environment that is called for in the student's IEP, but also of the parents' effort to continue to work with the school district to confirm the information they gleaned from the site visit, but as well to secure an alternative placement. Recall, the parent asked or informed the CSC that they would consider an alternative placement, and a response was not forthcoming. Now, we know, and we've discussed this before, it's the attorney's responsibility in the first instance to build the record. But certainly when discussing the claim with the parties, whether at the pre-hearing conference or prior to the hearing, we can establish our understanding of what we need in the record to make an informed decision. And DC provides an example of the type of evidence that should be considered. And as I said earlier, I would submit you have the authority in the attorney's failure to provide you with the necessary information to complete the record with the type of evidence that will allow you to make an informed decision as to whether this is a permissible challenge to the prospective placement consistent with MO. Third, I would be remiss if I did not point out that the Second Circuit in BP raises new questions regarding the permissibility of relying on subsequent testimony by school district personnel to rehabilitate faulty information given to the parents during their tour and subsequently relied upon when making their placement decision. BP suggests that the AP and nurse's testimony should have been considered. I wonder whether the outcome in DC would have been different if it followed BP. Before I move on to the last case that I want to discuss that I believe play out to one degree or another some of the points that I've been making, do any of the panelists have any of the reactions to the observations I just made regarding DC and the overlap with BP?
I do.
Okay.
DC was the subsequent year to a case I heard.
Yes.
So I have detailed recollection of how extraordinarily bad the district's case was.
Hmm.
And it sounds as though it was identical in the subsequent year.
Right.
I can tell you a lot about the case. I don't think it's necessary, but I don't see anything in DC that suggests that the that the department's witnesses weren't heard.
Hmm.
It's a question of credibility.
Hmm.
Uh, the IEP itself had the words seafood-free environment on the IEP. Personally, I doubted that the child needed it based on the clinical evidence, but the CSE thought the child did. The child was a girl, by the way.
Okay.
And in light of the IEP saying something as strong as that, I felt personally compelled to see whether the district was offering such an environment at any point in time.
Hmm.
And one of the things that wasn't clear in the district court decision, but was clear from the district's practice in both years, was that the New York City's practice with respect to allergy is generally that an allergy plan is only drafted after the child enrolls. And so you can't know what steps the school will in fact take until after the child enrolls, and you have no way of knowing whether those steps would be viewed as adequate in a life or death situation.
Sure.
So I read DC as being a case that's strongly about, as you described it earlier, it's strongly about parents' capacity to participate and make meaningful decisions. And so it's kind of sideways of the line that BP is in and that MO is in, which are about challenging substantively what's going on in the school.
I like.
I think the strong argument in DC is that these parents were in the dark at a point in time when they should have had proper information.
Can I follow up on that and ask you, because I'm curious to your point, since you since you heard at least the earlier case on DC. I said that, at least when I read DC, the 2013 case, this is not about capacity to implement. You
Right.
can you
Willingness.
can make this case. You can make this school seafood free if you're inclined to do so. So I'd like to hear your thoughts, John, on this issue of, well, do parents, school districts, is there the ability to make the argument that is not just a failure to implement because of capacity, but they're just not inclined to do so?
This case, and it played out in the context of the testimony that I heard, is well, a couple is an artifact of New York City. Um, it's a huge system, as we all know. It turns out in that huge system, the Office of School Lunches, it's not an instructional office. It doesn't report through the instructional side of the house. It follows a whole bunch of federal regulations. It's system-wide, the management is, and the principal has no control over the people serving lunch in the school or preparing lunch in the school. So one of the things that turns out to be the case is that there is no way to control what's served in the school, and isolating the child doesn't make it a seafood-free environment. Does not make the building a seafood-free environment.
Okay.
So, it's very much an artifact of New York City, and the testimony, I'm sure, both years, because they didn't change how school lunches is served. The principal said, "I can't control it."
Right. Right. Michael, can you mute yourself because we're hearing the paper rattling in the back?
Well, actually, I was on because I wanted to make a comment, if I
Oh,
could.
okay. Then make a comment.
Sure. I think that the fact that the school wasn't seafood free at the time the CSE made its recommendation really doesn't matter. The question was whether it had the capacity to make itself seafood free. And John may be right. It may be a question based upon the way New York City operates that it didn't have the ability to make itself seafood free. But it's a question of fact. Did it do so? Um, and in this case, I think the thing that made this decision so self-evident is that there was a representation made to the parent at the time the parent was making the decision to accept the placement or not, that they didn't have the ability to make it seafood free, and death is a pretty compelling equitable factor. So I think that the decision was decided exactly the way it had to be, and there's really nothing surprising in this decision.
But how is that
spot on.
different to the facts in BP, where the parents were told by the social worker that we can't implement the IEP? How is that any different? The parents were told in DC we can't make it seafood free.
Well, I think that in DC, the parents sounds like they made some extraordinary efforts to try to communicate with the district concerning whether or not they could in fact make this building seafood free. And at some point in time, whether it's one staff member or more, the parent is entitled to rely upon the representations made by the people that are offering them the program that they can't. And in this case, the fact that the representation that they couldn't might very well lead to the death of their child, I think made this decision a fairly easy one.
Which goes to the weight of the evidence that was in favor of the parents to corroborate what they were saying, to bolster their credibility or whatever, which was the point that you were making earlier regarding the one school official. Let me talk about TF.
Steady, if I could just say one other thing by way of background, which is that the kid was, in fact, had a 10-month program, which made it more complicated because all the people available in the summer were not the people who knew anything at all about the school year program.
Okay.
So that's yet another wrinkle.
Okay. And the case you heard, so just I'm clear. The case you heard was not the underlying hearing that ultimately.
That was another hearing officer's case. That was
Okay.
a subsequent year. My case was not appealed.
Okay.
My case was appealed to the SRO. I decided for the parent it was appealed to the SRO. The SRO overturned my decision in pretty much the same terms he did the second time. My decision followed almost exactly the reasoning that DC eventually followed. The case came up as set. They chose not to appeal it, I think, for reasons that had to do with the context in which my year arose, and they didn't like their facts. They brought it again immediately and appealed that one.
Okay. That's helpful to know. All right, let me talk about TF, which is the last case I want to talk. And again, as I said earlier, the observations that I talked about in DC, BP, BK, they seem to play out to one degree or another in TF, which just emphasizes for me the types of nuances that these cases are going to be presenting to you, and that I do this just so that you see how this might play out differently, and the types of things that you need to consider when one, prepping for the cases, one, setting expectations from the parties, and three, thinking about how to apply the facts to the standards. In TF, again, a Southern District case, late 2015, by late I mean early fall, it's cited in footnote 15. We have parents of a child with Down syndrome who met with the Committee on Special Education and raised concerns in writing about the IEP that was ultimately recommended. The school district did not respond to any of the issues that were raised by the parents. Subsequently, the school district notified the parents of the recommended placement school, and the parents went on a visit. After their visit, they set forth their concerns in writing in a letter to the Committee on Special Education, but no one responded to the parents. The parents then visit the school a second time. and reiterate their concerns in a second letter. But again, there was no response to that letter. So 3 written communications to the Committee on Special Education, none are responded. Very similar in terms of the parents' engagement with the Committee on Special Education in DC. During the parents' visits, with respect to the concerns that they submitted to the Committee on Special Education in writing, the parents spoke to several teachers who, according to the parents, suggested that the school would not be appropriate for the student and that it would not be able to implement the IEP. So, TF, parents speak to more than one teacher, and they're told the school can't meet the requirements of the IEP. It will not be an appropriate placement for the child. The parents aver that they were told specifically that the student would not be able to participate in the school's internship program. Now, I'm going to surmise for purposes of our discussion, because it wasn't very clear in the decision, that somehow this internship program was either related to some transition services or help with some of the annual goals that was set forth in the IEP. But the parents were also told that the student was unlikely to receive the related services listed on the IEP. Both the hearing officer and the state review officer relied on the testimony of an assistant principal who testified that the information that was received was mistaken. Again, this is after the visits, after the notice of unilateral placement, after the filing of the due process complaint. The parent is now sitting in the hearing room, and the assistant principal says, "Parent, the information you received was mistaken." Unlike DC, the court here says that while recognizing the failure of the school district to respond to the parents' letters, which the court labeled as, quote, troubling, the court nonetheless found against the parents because their allegations did not rise above speculation, and they failed to point to any definitive evidence that the student would not have received the services listed or set forth in the IEP. Again, TF, a case that has some of the ingredients of DC, which fines for the parent, some of the ingredients of BP, or some of the problems that the parents in BP weren't able to overcome, i.e., they were relying on one school official. Here, the parents presumably had more than one because multiple teachers told them that the school cannot meet the needs of the child as stated in the IEP. But the district upholds the state review officer and fines against the parent. 4 cases that elucidate on, and I use that word loosely, the distinction that MO is trying to make, but very instructive in terms of how we need to look at these cases moving forward. And the cases meaning when the parent is putting forth um, an argument regarding a prospective challenge to the student's proposed placement school. Code number 4 is on your screen. Code number 4 is on the screen. Please write code number 4 on the slot on your affirmation form. Code number 4 on your screen. Moving on. There are other decisions Some cited to in the outline, like the four I just discussed. And though the court in MO provided some needed clarity, I'm not entirely convinced that it has climbed out of the hole it made when it decided RE. Perhaps it dug it even further. I think there's going to continue to be some disagreement among the district courts in implementing the holdings in RE and MO, which admittedly may have some benefit for you because it will provide you with some level of discretion on what is a permissible prospective challenge and what is an impermissible prospective challenge. The nuance in BP, understanding with the asterisks, the narrow reading that John has proffered, though coming from an unpublished decision, will inevitably, in my opinion, introduce new arguments that you will need to decide. And perhaps John has offered a way to address that argument. But I suspect, and I would like to hear from you in the weeks, months to come, since BP is fairly new, whether you will start to hear some BP type arguments. I like to, because I think it's important, to take a few minutes to discuss burden of proof and caution against misappropriating the burden of proof in these types of challenges on parents. It is essential that you do not conflate the school district's burden set forth in section 44041C with the parent's responsibility to rebut the presumption that the placement school will fulfill its obligation under the IEP. Courts presume that the placement school will fulfill its obligation under the IEP. I cite to some examples in footnote 24. These are examples of cases in our circuit. And though they recognize that the school district bears the burden of demonstrating the appropriateness of the student's IEP in placement, inclusive of, to a lesser extent, the designated school, in prospective challenge cases, the parents must come forth with prima facie evidence establishing that the school district would not be able to implement the written plan. But importantly, once that prima facie evidence is presented by the parent, the duty on the part of the school district to provide evidence regarding the placement school's adequacy is triggered. The school district continues to have the burden to now present you with testimony that in fact the recommended school has the capacity to provide the services as set forth in the IEP. I felt compelled to put this in the outline and put this in the presentation because there is at least one case, and I can't remember which case it is. Give me a second while I look at the footnote. John, do you recall the case in which the court, the district court, seems to again use poor language and talk about the parents' burden, etc. And it's a 2015 case, and I want to make sure that you understand that I believe this is a poor use of words or perhaps a misunderstanding by the district judge of where the burden of proof properly lies in these types of cases, capacity to implement cases, and in any other case that comes before you as hearing officers.
The only thing that comes to mind actually is the misstatement of the allocation of the burden of proof in RE, which flatly states that the burden on the equities is in New York State is on the parents. I basically, that's the only one that I'm aware of and have been furious about for years.
Yeah, I believe, and don't cite, you're going to read these cases on your own. It may very well be JW, which is cited in your materials at 28. I'm just looking at my my outline and trying to, refresh my recollection at this late date, a late time of day. But there is another decision out there where the judge seems to talk about the parent's burden to demonstrate. And I think when you read it and you read it closely and you look at it in the context of everything, and you obviously have to read it in the context of the of New York State law. I think the judge is mistaken, used poor use of words. The burden of proof continues to be on the school district.
It's the burden of production, really. I mean, the truth is
that
that
might be true.
the prima facie burden of proof with respect to placement is simply to show that they offered a placement and to provide a witness who can be voir dired about the placement that was offered. And once they've done that, the burden of production does shift.
Yeah.
But the burden of proof doesn't. The burden of persuasion doesn't.
Right. Yep. So I have a few slides to go. I have about 11 minutes. I will like to get to any questions or comments from the panelists, but let me get through the final. I think I have like 4 slides left before we entertain any questions, because I do want to end on time for those of you who have other responsibilities beyond listening to me this evening. Interestingly, in RE and then again in FL. And again, I just want to elucidate this just because I sit here and I scratch my heads, and you might be wondering, what the hell does this mean? In RE and then FL, and FL is cited in the outline at footnote 25. The Second Circuit makes yet another perplexing statement. In perhaps an attempt to reassure parents that they're not without recourse, the court points out that the appropriate forum is a, quote, later proceeding, end quote, to show that the child was denied FAPE because necessary services included in the IEP were not provided to the student in practice. What later proceeding is the Second Circuit referring to? These cases come up in the context of tuition reimbursement. You get one bite at the apple per year. Though likely it was well intended, the court's reassurance is like being sent home with a year's supplies of noodle-roni as the consolation prize. Do you remember those game shows back in the 80s, 70s, late 70s, where you're like, here's your consolation prize, and they give you a whole bunch of boxes of noodle-roni? That's what it felt like to me. It's like, all right, a later proceeding. You have a later proceeding, the option of a later proceeding to argue that this, that they didn't do this. We're talking about tuition reimbursement. What later proceeding? My kid is sitting at the private school, and I've laid out that money already. Perhaps in the context of a reimbursement case where the student is still sitting in the public school and seeking prospective funding, perhaps you can justify what the court was talking about in RE. I'm not sure. In practice, what the court is talking about is failure to implement claims, which by definition require the student to have been sitting in the public program offered by the school district. I'm not going to spend a lot of time talking about failure to implement claims, because though it's a dimension of FAPE denials, it's not entirely on point with the capacity to implement claims. But the court mentions it in RE and FL, so I will as well, albeit briefly. And mind you, in New York, the court in MO seems to have created a fourth dimension of FAPE denials. We know the other three. One is procedural violations. Two is substantive violations. Three are the ones that we're talking about now, failure to implement claims. And now we have, as a result of MO and RE, capacity to implement claims. Those capacity to implement claims are not things that you will hear in other jurisdictions outside of the Second Circuit. Now, I do want to point out that although I'm talking about failure to implement claims, the Second Circuit has not squarely addressed the question of what standard governs failure to implement claims under the IDEA. The consensus approach in New York has been to adopt the standard in Bobby R., which is a Fifth Circuit case. In Bobby R., the Fifth Circuit held that, quote, a party challenging the implementation of an IP must show more than a de minimis failure to implement all elements of the IP, and instead must demonstrate that the school board or other authorities failed to implement substantial or significant provisions of the IP, end quote. In other words, courts are looking to ascertain whether the aspects of the IEP that were not followed were material. Substantial, significant provisions of the IEP, whether the failures were material. A material failure occurs when the services a school provides to a child fall significantly short of the services required by that child's IEP. So only material failures are compensable under the standard in Bobby R. that has been adopted by consensus by New York courts, including the Second Circuit that has referred to Bobby R. Any minor discrepancy is not compensable in failure to implement cases. The materiality standard does not require that the child suffer demonstrable educational harm in order to prevail. The parent doesn't have to come in and say, listen, you didn't provide my kid speech and language services for the entire year. And as a result of that, he has suffered harm. That's not required in the standard that was adopted by Bobby R. and as well as the Ninth Circuit that has a variation of Bobby R. Is it Van Dyne, Lynn? I don't remember the Ninth Circuit decision off the top of my head.
You're right. It's Van Dyne.
Yep. Okay. But this said, although you don't have to show educational harm, the child's educational progress or lack of it may be probative of whether there has been a significant shortfall in the services provided. In other words, the school district, for example, can affirmatively assert that although parent, you don't have to show harm, I'm going to show progress, that even though we screwed up, even though we didn't give the child the speech and language services for the entire year, nonetheless, hearing officer, you should consider the fact that the child not only didn't suffer any harm, he or she progressed. And you should take that into consideration when determining whether there was in fact a material failure. That's all I'm going to say about failure to implement claims. Again, because though there's some overlapping principles with capacity to implement claims, which is MORE, they're not necessarily one and the same in the context of tuition reimbursement claims. But I did want to mention it because RE, MO, and some of the district courts kind of throw it in there in their analysis of the cases that they were deciding. We have a few minutes, 2 minutes, Lynn, for any questions, any comments from the panelists before
Well, let's
I
see.
show the last um, code.
Our panelists were so helpful. Why don't we get their comments first if they have any?
Okay.
Well, I would like to go back to a couple of comments that Mike made, because I think they join together, and stress that there's a real distinction between questions of fact and bright line questions of law that say you can't talk about this. And so much of what arises in placement claims really have to be questions of fact and questions of equity. And it's wrong for people to interpret the courts as saying you can't hear these questions, which is not the same as saying that they're often going to be successful. But any bright line statement that you can't hear, not just capacity, not just willingness to, but even a significant question of likelihood of implementation. People should be able to say what evidence they've got and let the hearing officer determine whether it's speculation or not.
Good point.
But I think it's also important to bring back Deasteti's earlier point that sometimes they'll put something out there, but then I think it's incumbent upon us as the hearing officers to ask the questions to clarify. Why were you offered opportunities to do this? Did you make any further inquiries? District, did you do this or that? In order to draw out all those facts, John, that you're alluding to, because they may not come forward, and then you'll sit there later to make your decision, look at these cases and say, damn, I would have asked that. I wish I would have asked that question of either the parent or the district.
Yeah, absolutely right.
Just let me interject here while you continue your dialogue. Code number 5 is now on your screen. Code number 5 is now on your screen. It is 6 o'clock on the dot. I am a stickler for time, and I promise you not to take more than 2 hours. You can stay on while you listen to these last few minute comments, but code number 5 is on your screen. Before I sign off and let John, I guess, respond to Lynn, I do want to thank you. I know that it's 2 hours of your evening. I do appreciate you taking the time to join us and hopefully get something out of what we discussed today. So for those of you who might sign off, good night. John, go ahead, finish your thought, John.
My thought is simply to agree with Lynn. That's the nature of factual inquiry, and you need to do it, and you need to do it with a full record. And if they don't present you with the full record, you need to take the necessary steps to make sure you have the full record. And then you make the decision, and you make the decision in the context of the case law.
Thank you, and I'll leave it at the fact that someone has agreed with Lynn. I'm sure he says, let's leave it at that point. Make sure you get me those affirmation forms by January. What was the date that I told you? January 22nd, Friday, January 22nd. I want to thank the panelists, John, Debbie, Michael, for your insight. I think you've added value to tonight's presentation. Good night, everyone, and we will see each other, or at least hear each other, in March when we have our second webinar. Good night.